Turn to M3 and Karen B for this week's episode of Comply on the Fly. You'll get quick and timely answers to the most common employee benefits compliance questions so you and your business can keep moving ahead. Please note this podcast and the contents herein do not constitute legal advice. Please seek the advice of counsel for any benefit compliance-related implementation, guidance, or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question of the week is, can you please verify if it's mandatory in Wisconsin to run workers' compensation benefits and FMLA concurrently? First, this is a Wisconsin-specific question. So if you are wondering about other states, you will need to know if that particular state or states has a leave law or laws separate from federal FMLA. Second, you will need to determine if the employee qualifies for both federal and state leave. If the employee qualifies for both, then when applicable, you would run both leaves concurrently. Now here, I want to back up a bit because sometimes there are misunderstandings about work comp or disability policies, such as STD, short-term disability, or LTD, long-term disability. These policies provide monetary compensation in case of injury or disability, generally not leave from work. So if an employee is receiving workers' compensation benefits or disability payments, and they need to be off work, then you have to apply FMLA or your own leave policy to the situation. That is very important to understand. Now, finally, back to the question at hand. Federal FMLA allows employers to require that employees use any form of paid leave during unpaid FMLA, which includes workers' compensation benefits or disability benefits. However, Wisconsin state leave laws state that it is only the employee that can decide if available paid leave will be used. In other words, employers in Wisconsin cannot require what we call substitution. So how does this play out? Remember, federal FMLA is one bucket of 12 weeks for any qualifying reason, and Wisconsin leave provides for separate buckets of time for different reasons. 2 weeks for the employee's own serious health condition, 2 weeks for the serious health condition of a family member, and 6 weeks for the birth of a child. If the employee is eligible for both Wisconsin and federal leave due to their own serious health condition, you would run the time concurrently. The law that is more beneficial to the employee would apply. So technically, there are 2 weeks of leave where a Wisconsin employer could not designate FMLA while the employee is receiving work comp or disability payments unless the employee agrees. The Wisconsin Human Resources Handbook specifically states, quote, any period that an employee is absent from work while on workers' compensation or hazardous duty disability leave should not be counted as time used under Wisconsin FMLA, but it may be counted under federal FMLA. So in theory, this could result in an additional 2 weeks of time for someone under Wisconsin FMLA to be used at a later date. The bottom line is to understand both federal and state leave law requirements when you have someone who needs to be off work due to a work-related injury while receiving workers' compensation, or where they're receiving long-term or short-term disability payments. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.